I'm planning on filing a petition for probate, and I was told I may need a bond. What is a bond? Why do I need one? And how can I avoid it? Hello again. This is Certified Probate Real Estate Specialist Daryl Williams with Win-Win Realtors here in Southern California. If you are new here and you like our content, be sure to like, share, and subscribe. Let's get started. In the state of California, a bond is basically a mandatory insurance policy that a petitioner must secure prior to being granted authority to administer the estate. The purpose of the insurance policy is to protect beneficiaries from an executor's mismanagement of the estate's assets. The bond is based on the total value of the assets, and these assets must be maintained until the estate closes. If the petitioner is able to secure the bond and file all of the appropriate paperwork with the probate court, then at the initial hearing, the judge is likely to sign the letters of administration if there were no will, or the letters of testamentary if there were a will. These are the documents that gives the petitioner the authority to administer the estate. When are bonds needed? Generally, a probate bond is required by the court when one person is handling the affairs of another. Generally, when are bonds not needed? If the decedent died testate, meaning with a will, and the will says no bond is required, or if all of the beneficiaries waive the bond requirement. The bond basically is a guarantee that says to the beneficiaries, if there is mismanagement, fraud, or error, the losses can be recovered. Another important consideration, even if the will says waive the bond, however, the judge has reservations about the petitioner, or there are arguments among the beneficiaries, then the judge may go ahead and require a bond, even though the will says to waive the bond. Even if a petitioner has a significant amount of debt, the judge may require the bond. Almost always, if the petitioner lives out of state, the judge will require a bond. Remember, it's all about protecting the interests of the beneficiaries or heirs of the estate. So, how could you avoid a bond entirely if the decedent had a will and the will says no bond is required and there aren't any other issues in the estate? You'll avoid the bond that way. Or if all of the beneficiaries waive the bond requirement, you will not need a bond. Question of the day: have you ever served the role as a PR, a personal representative, in a probate? Did you have the bond waived, or were you required to secure a bond? Let us know in the comments below. One very important note is the petitioner must be bondable. You must be able to secure a bond. If the petitioner is unable to secure a bond, it is likely a new petitioner will need to have to administer the estate. I'm Daryl Williams. This is Win-Win Realtors TV. If you have any questions for me, don't hesitate to reach out to me. My contact information is in the description. This video has been for information purposes only. It is not legal advice. I am not an attorney. If you need an attorney, please contact one. If you need an estate planning or probate attorney here in the Southern California area, feel free to reach out to me for a referral.